Hi, I'm Jorge Contreras, and I teach here at the College of Law. So for a number of years, while I was both a practicing lawyer and as an academic, I have looked at technical standardization. So what we're talking about are the types of standards like 5G and Wi-Fi and USB that enable technical devices to connect to each other, whether they're made by one company or another. These standards are important. There are literally trillions of these devices around the world, from phones to laptops to cars. The standards that enable them to interoperate are developed by engineers who work in groups under the authority of bodies called standards development organizations. So, in some cases, like 5G, you have literally hundreds of companies working together with thousands of engineers to come up with what the next standard is going to be. And as you can imagine, these are technically complex protocols, and so patents become an issue. If a company has a patent that covers one of these standards, then any company that has such a patent can prevent manufacturers from making products that implement the standard without their permission. And as a result of this, you have lots of companies that potentially have the power to block a standard from being adopted widely. And this, in the view of the standards organizations, is a problem. So over the years, standards organizations have developed policies to ensure that manufacturers have the ability to implement products that have these standards in them. And one of those policies requires patent holders to make available or license their patents covering the standard. And so there are two potential issues that arise when this happens. The first is the amount of the royalty. How much is it going to be? The standards organizations don't tell us this. All that they say generally is that the royalty has to be fair, reasonable, and non-discriminatory, or FRAND. But what FRAND means is a question, it's a billion-dollar question that nobody really has the answer to. It's being hashed out in courtrooms and arbitration panels all around the world. Then, the second question is, what happens when you put all of these royalties together? Even if a royalty might be fair in terms of one patent holder, what happens when you have 100 and you add them all up? How much is that total stack going to be? So as you can imagine, this has led to disputes all around the world surrounding what the level of the royalties ought to be, both individually and in the aggregate. This has led to a wealth of proposed solutions, and scholars like myself and many others around the world have been involved in a decades-long discussion of how we can deal with these issues. Recently, the European Commission made a proposed European regulation that would create a registry of patents covering standards, require some disclosures, create some non-binding determinations of aggregate and individual royalty rates. And that's a great first step. And I and many others have been involved in commenting on and analyzing that proposal. There are a number of other proposals, though, outside of the European Union, including some that have been percolating in the US and the United Kingdom. I've been involved in working with government agencies in both of those jurisdictions to think about how we can best rationalize the FRAND royalty system in those countries and internationally, whether that's through some sort of non-governmental arbitration system or a national-based system, country by country, that will address the FRAND royalty disputes, at least from country to country. The stakes are fairly high. If we don't get these issues under control, we may very well have less innovation in certain product categories. We may have fewer new entrants to some of these technology markets. We may have countries start to go their own way and avoid international standardization. This has happened in the case of China in a number of important industrial areas. And that kind of fragmentation generally isn't good for world markets. And then finally, there's a potential impact on consumer prices, which again are not benefited when royalties and costs are too high.